Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and two things on the dock today. One, Patrick Frazee had a pretrial conference for his trial that starts October 28th, and all the contestants have come forth for the Dumb Criminal of the Week, and the winner will be crowned. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning into our little channel, the channel that wants the facts and not the speculation. Here today on the docket, first, Patrick Frazee. For those of you who do not know, Patrick Frazee is a man who is accused of killing the mother of his child and his ex-girlfriend, possibly fiance, Kelsey Barrett. Patrick Frazee is charged with first-degree murder, and his trial is scheduled to start not this Monday, but the following Monday, October 28th. A pretrial conference was held today on some last-minute evidentiary issues, as well as issues relating to discovery, which is documents that the prosecution has to turn over. And for those of you who don't know, a quick recap. Patrick Frazee is accused of killing his mother of his child, Kelsey Barrett, and his other girlfriend, who was a nurse from Idaho named Crystal Lee Kenny, who was also married at the time, but is now divorced, came to Colorado a couple occasions, and she was going to, by her own statements, kill Miss Barrett. She says she ultimately did not. So she panicked every time, went back to Idaho, but then came back after she alleges that Mr. Frazee killed her with a baseball bat and had her come out to Colorado, clean up the mess, and then help dispose of the body. Miss Crystal Lee Kenny received a smoking good deal, and I mean a smoking good deal. She was possibly a conspirator, certainly complicit in the planning of a murder. At a minimum, she is an accessory after the fact, but she gets tampering with an evidence charge, which is a Class 6 felony in the state of Colorado, which only carries 12 to 18 months in the Department of Corrections. And if there were aggravation factors that the court could consider, it could be as high as 3 years. Miss Kenny, when she pled guilty, says basically, I'll accept up to 3 years in DOC as part of my cooperation deal and sentence, but I'm still eligible for probation. So you'll think about that, Judge, right? There was some talk about whether the defense had endorsed alternate suspect. You know, the prosecution has to prove that it was Mr. Frazee that did something. The government still has to prove that Miss Barrett is in fact deceased. We've talked about this case from the beginning. I thought it would be interesting. It's kind of like the Photos Dulos case in Connecticut, where there is no body, hence the reason why he has not been charged with murder. Here, I think the prosecution jumped the gun, and there is no body. There's been evidence, at least talked about, testing what they believe to be a tooth or a bone, perhaps recovered from the ranch of Patrick Frazee's mother, where it's alleged that Miss Kenny stated that the body was burned. But nothing absolutely credible at this point that what we have seen, or definitive as well. The prosecution has a heavy burden on this particular case, and the defense has an absolute gift because Crystal Lee Kenny all but says she was going to kill Kelsey Barrett on multiple occasions, but chickened out. But this one time she just didn't do it. Oh my gosh. Any juror is going to say, ooh, you're a prime suspect in this particular matter. And that's where I believe the defense is going to go on this. So what I love about this from a defense perspective, and I have won 7 first-degree murder trials, okay? And what is the best defense? The best defense is going forward on the first trial setting. Most district attorneys never expect a defense to go forward on a first trial setting. And Mr. Frazee and his counsel have said, nope, not guilty, let's go to trial. And one of the issues that came up at the pretrial conference was the defense attorney for Mr. Frazee was saying, Judge, I just got hit with another 6,000 pages of discovery. Okay, 6,000 pages of discovery that you have to review, organize, analyze, see how it fits into the case. Is there something exculpatory? Okay, typical prosecutor crap that they pull when they're not ready, okay? If they had 6,000 pages of discovery that was just turned over last week, why in the hell wasn't it turned over weeks, months ago? Okay, at a certain point, the discovery has to stop. Now, under Brady v. Maryland, the prosecution has to turn over everything in their case. They don't get to hold anything back. And that's the way it should be. The defense is very limited in what they have to turn over, if anything at all. But the prosecution has to turn over the good, the bad, and ugly to the defense, and particularly if it's exculpatory. Exculpatory means if it were to do anything that would reduce the potential guilt of the defendant, the prosecution has to turn it over. So in those 6,000 pages, there could be something good in there for Mr. Frazee, and that's why the defense attorney will probably be working nonstop over the next week to get everything done and ready to go. And I hope, and I think it is best shot if he's going to win this case, and I'm not saying he's going to or he should, I'm just giving some analysis here, that if he's going to do that, he needs to go on the first trial setting. Because, ladies and gentlemen, let me tell you this. The prosecution is like a big steamroller. The government, the prosecution, is real slow to get going. But once that steamroller is going, you don't want to step in front of it, okay? And it looks like the steamroller is still a little slow, because if they got 6,000 pages that they're just turning over to the defense, that also means that they got witnesses that they haven't endorsed yet. That means there's people that may not be able to show up for court if they need that information as well. So it's going to get interesting. Second thing that was interesting about the pretrial conference, the court did in fact limit some of, the prosecutor was denied using some evidence because of the late production of this. It's unclear how important that evidence would have been to the prosecutor, but the mere fact that the judge is saying, no, I'm not going to let you do whatever you want, prosecutor. You've had time to do this case. When you bring this case, you basically are telling the defendant you are ready to go try this case, and why are you dumping all this stuff on the defense at this time? Additionally, the court clarified that no one should be giving press conferences regarding this case. The defense was upset that the court administrator, now the court administrator is the one that actually kind of works for the judge, and he was sending out information, and the judge said, that's okay because that's coming through me, and they're going to keep it clean. But neither side should be spinning the facts of the case. The key moment in this case is going to come when Crystal Lee Kenny is called to the stand and what she has to say. This is going to be an interesting case. It is so unfortunate that the judge said that the courthouse was so old in Teller County that it was not suitable and not large enough for what they refer to as expanded media coverage, which is basically videotaping the trial. Really, Judge? I mean, it is 2019. I think we have cameras small enough. Technology has advanced as such that I think that we could probably figure out a way to televise it without showing the jurors in this particular case. Now, and let me digress. So one thing that was rather interesting is that the court did rule that some of the text messages from Kelsey Barrett would be admissible in court. And these are text messages to her mother, basically saying that her relationship with Patrick was somewhat hilly or shaky, and that she had listed plans of what she was going to do over the next several days. And so I said to myself, how is that not hearsay? How is that not inadmissible hearsay? And I'm trying to think under what exception could it possibly come in under? So we did what we do oftentimes when we just want to be absolutely certain. We break out the actual rules of evidence. And so for most people don't know, the rules of hearsay are under the 800 rules in both most states and the federal rules of evidence. And a statement is an oral or written assertion or nonverbal conduct of a person if it is intended by him to be communicative. All right? And it says the declarant is the person who actually makes the statement. And hearsay, here's the definition, the legal definition, 801C. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. Okay? Let's break that down. It's only hearsay, and in a trial, the rules of evidence should be applied, obviously evenly. But if somebody gets on the stand, they only can testify as to what they saw, what they observed, what they heard, what they smelled, tasted, that kind of thing, right? Who, what, when, where, why, how. What did you see? Where did you see it? When did you see it? But it has to be that person. Somebody can't come to court and then testify as to what somebody else said and said, oh, I spoke to the cab driver who said that they saw this. That's all hearsay. It's inadmissible. Now, there are a ton of exceptions, but I can't find an exception under which I would allow that text message from Kelsey Barris' mother to come in. She's not available, okay? It's clearly a statement to be a communication, and it's going to be made by somebody else, and in this particular case, probably her mother testifying to what somebody else said to her. That's hearsay, okay? You can try to say, well, and this is probably getting too much in the weeds, but it's not being offered for the truth of the matter asserted, which my position's always been, if it's not being offered for the truth of the matter asserted, why is it even relevant then? It shouldn't be. And then they're going to probably say, well, it's not being offered for the truth of the matter asserted, it's for the impact on the listener. What did the impact on the listener says? Well, I thought that she had plans and that she wasn't leaving anywhere. Okay, guess what? So what? Complete speculation, right? Maybe she's saying those things to tell her mom that this is the week ahead. Maybe she's planning to leave. Who knows? But the point is that's speculation, and it doesn't come in, and it shouldn't come in. So I'm a little surprised by the court's ruling on that, but we'll have to wait and see on the context in which it comes in. And in criminal cases, most people don't do these rulings super far in advance because you have to wait how it comes out of trial. That's why you have to object. That's why a defense counsel always seem like they're objecting, or they should be, if something doesn't come in or shouldn't be coming in, because if it's not objected to, it's not an appellate issue on appeal if the defendant loses. So huge digression there about hearsay, but it just chaps my hide when the rules of evidence are relaxed because they think it will, they need it to help the prosecution's case. It doesn't matter. Judges, and we've talked about this before, should only call balls and strikes. They're not a party in this case. They have no interest in the case. They should not care one bit or the other if the prosecution can prove their case or not. Next thing on the docket, the dumb criminal of the week. Let's quickly go through our previous contestants and give you a brief update. Tommy Lee Jenkins, remember him? He faces a count of using a computer to entice minors, but he walked 351 miles only to find out that his young 14-year-old potential date turned out to be a police officer. Our next contestant for this week was Richard Decker. He's 31. He's the man that was charged with retaliating against farm owners when he wrote letters asking if he could have a relationship with their equine animals because he's attracted to equine animals and would frankly have his own horses at his house if he had the space. And when the farmers said, dude, you're a creep, he started threatening them and doing things that would flatten tires. That's just weird, right? Our next contestant was Nicholas Sheehy, 23, who went to the dollar store and thought that he would meet young ladies by flashing his genitalia at them. Obviously, it didn't work. The only thing that was picked up was him when he was arrested for indecent exposure. We also have two contestants today. The first is Joel Benjamin. He's 71. And Joel Benjamin had a little dispute with his neighbor, and he thought it would be appropriate that when he had contact with this neighbor would be to squirt her with a squirt gun that just happened to be filled with his urine. Mr. Benjamin was convinced that his neighbor was spying on her and was part of a government surveillance plan. And yes, the final contestant for the dumb criminal of the week is Lynette Stewart, 37 years old. Whose car has run out of gas, but she was able to make it to the filling station, fill up her gas can, And what's the logical thing to do if you see a police officer? Wave the officer down, saying, please, can you give me a ride to my car so I can put this gas that I just purchased from the gas station in the car? The officer, being a good guy that he was, what did he do? He drove her back to her car. Well, it just happened to be that it really wasn't her car. Her car was stolen. Yes, ladies and gentlemen, the winner of the Dumb Criminal of the Week, Lynette Stewart, because she's just dumb, okay? The other contestants were just creepy and weird, but Miss Stewart is, in fact, dumb. She is the Dumb Criminal of the Week, and if Miss Stewart contacts Crime Talk at scott@scottreisch.com, then she will receive a Crime Talk mug, courtesy of me, shipped directly to her at no cost. Which brings me to one last thing, ladies and gentlemen. First of all, we appreciate everything that you do, and we appreciate you watching. We hope that you enjoy our content. We really do, and we try to come up with relevant information for everyone and provide some knowledge and information on the law. So if you like the channel and you haven't done so already, please hit the subscribe button. If you like the video, please hit the like button. And if you want to receive notification of when we go live, please hit that notification bell as well. If you would like to get that Crime Talk merchandise, you can do so below. If you would like to get some advanced information and bonus things, then you can also sign up for the Patreon. And if you really just like free stuff, you can go to scottreisch.com and sign up for our newsletter, and you'll get information from me as well about cases and other things that, frankly, I just find somewhat interesting. So thanks for watching. Have a great day. We'll see you next time on Crime Talk.